Welcome to the Cybersecurity Podcast by AC Council. I'm Jay Bavisi, and today we're speaking about a very interesting topic, cyber incidents and cyber law. My guest today is Joanne Elieli, a partner from Stevenson Harwood LLP from the United Kingdom. This is not LA law, or this is not a series of suits, but we're going to be talking about bits and bytes and how it bites into the cyber arena. Welcome to the show, Joanne.
Thank you so much. It's so nice to be here.
Likewise, we are really excited to have you here because this is a very interesting topic. So, to start, Joanne, you obviously went to school as a lawyer.
Yeah.
How did you get into cybersecurity? This is a very specialized area of the law.
It is. And, I get asked this question so often. I started out life as a general commercial litigator, so focused really on complex multi-jurisdictional disputes. And to a certain extent, that still incorporates a good part of my practice. But I think over time, I moved really into the tech space. And from that, moved into data protection and then cybersecurity. So we had the UK GDPR, or actually it was just the GDPR back then before we had Brexit, and that came into force in May of 2018, and that really was my first taste of getting involved in big data breaches that followed from that. Corporates really started to sit up and pay attention because now we had a regulator that had teeth and they could issue really prominent fines for data breaches. And so that really was my gateway into doing this sort of work on a more substantive basis. And it's really taken off from there.
So let's start from a regulator, biting, using its teeth to bite into corporates that violate, like the GDPR, for example.
Yeah.
What kind of fines have you actually seen, or what kind of fines have actually been reported, right? I mean, does this really hurt, or is it like a slap in the back of the wrist? How bad can it get?
It can get pretty bad. So the GDPR provides for the regulator to be able to issue fines up to 4% of global turnover for a corporate. And so when you're talking the likes of big technology companies or perhaps big airline, because we've seen data breaches happen for some of the very large airlines in the UK, that can represent a really significant chunk of a company's profits. Because we're not just talking about percentage of profits here, we're talking about percentage of global revenue. And so really that can take quite a significant dent out of a company's balance sheet for the year. So we're not talking kind of pounds and pence here, we're talking potentially millions.
Serious dollars.
Yeah.
So 4% of global turnover or global revenue, as we say here in the US. My question to you is this: if there's a subsidiary, all of these large organizations, right? The Googles, the Perplexities, the Apples, the Microsofts, they all have subsidiaries in the UK, and the subsidiary is wholly owned by a parent. And assuming that there's a breach at a subsidiary level, right? Now, how do you calculate global turnover or global revenue? Because you're not, legally speaking, you cannot go, upwards. You can go downwards. So how do you deal with that? Are corporations really worried? Because you could have a subsidiary in the UK that has a very tiny amount of revenue. I mean, comparatively speaking to a larger picture.
Yeah. So great question. And our regulator does have the ability to go up if they choose to. So this is what really makes global corporates sit up and pay attention. Now, there are arguments that we can make against that. And, there are fact-specific reasons that we can use if a regulator's considering issuing a penalty. Often, before a regulator goes ahead and actually proceeds with enforcement action, we'll have the opportunity on behalf of our clients to put forward submissions and to make arguments against or for different courses of action. And so that may well be one of the arguments that we put forward on behalf of our client, is that it's inappropriate for them to go up in this situation. But it's often very fact specific. And so we tend to say to clients, you should assume the worst case scenario here.
So the idea about piercing the corporate veil, as I learned in law school many years ago, that it's very difficult to do. In this case, it's one of the exceptions, I would say.
Well, it is still difficult to pierce the corporate veil from an individual director perspective. So in general litigation, it is still very difficult to go behind a corporate entity.
Right.
But actually, when we're talking about data breaches and the fines that could be issued, it is possible for a regulator to work its way up through the corporate structure and to be able to ascertain exactly where this data came from. sometimes you may well find that you have data processing agreements in place that stipulate a particular entity as being the data processor or the data controller, but in actual fact, that doesn't accurately reflect the reality of which corporate or which jurisdiction that data is being held in. And so in those situations, the regulator can, if they choose to, try and find reasons to go behind what may be put on paper.
That's great. Let's start by talking about ransomware.
Yeah.
Right. This is a very important topic.
Yep.
In cyber, we see a lot of corporations get crushed when they get hit by ransomware.
Yep.
But at the same time, ransomware is very prevalent. What's the largest ransom that you've dealt with in your professional
good question.
in your professional career?
I would say the largest is probably around the £10 million mark. But that was interesting because actually this case was a really fascinating one. Originally, the request was for much less. I think it was for about £500,000 to begin with.
Oh.
But actually, as part of the bad actors going through the documents that they had been able to access from our client's network and systems, they discovered that our client had a cyber insurance policy, which provided for a ransomware payment up to £10 million.
Wow.
And so then they upped their ask on the basis of having seen what was said in the cyber insurance policy. And so that's a really good example, actually, of the reasons why organizations should really be holding these really key, important company confidential documents on a separate secure platform so that you don't find yourself in a situation where actually you're paying 20 times more than the bad actor was originally requesting on the basis of them having been able to, go through all of your paperwork and establish exactly what you might have coverage for. So that was a really interesting example.
That's truly fascinating of a threat actors actually going through the documents, because most of us are under the impression they're very large, terabytes of data, and they don't really sieve through. It's a spray and pray, and hopefully someone pays and you eliminate the others. But here's a situation where you're actually seeing threat actors sieving through the documents, determining.
I should say that is the exception rather
sure.
than the norm. And I have only seen that in one isolated case, but it does just go to show that it's not out of the realms of possible.
Right.
And I think that's something that people do have a tendency to overlook.
So a great takeaway: keep all your legal documents and cyber insurance policies in a different system or a compartmentalized area rather than clubbing them all together. Because you get ransomware, you're going to have a tremendous amount of information shared.
Yeah.
Let's talk about a lot of our listeners are really perplexed as to what really happens in a ransomware environment, right? If an organization is actually subject to a ransomware. Now, obviously, you get called slightly later. I would imagine in a situation, but I don't think it's too far late, right? When an organization gets compromised and there's ransomware involved, just take us through what really happens. Do you get a call like what we see in Hollywood at 3 a.m. in the morning at Joanne? You're requested, right? It's an emergency, and then you show up, right? And you have an entire board waiting for you and say, Joanne, we have a problem. Or is this one of those that, the company has dealt with it, the incident has been responded to, and then there's a litigation, and then you come in, sipping your coffee and dealing with it over the next 9 months? What is it like in real world?
It's definitely not the latter. I don't get to swoon in with a coffee in hand,
right.
unfortunately,
That's
although I'd quite like it if that was the case. What's interesting to your first point about, imagining that we get a call a little bit later, actually one of the first things I recommend to our clients is that legal should be the first people that they call. And the reason for that is then we get to be involved right from the outset. And that means that we get to put the banner of privilege over all of the communications that are happening from that point forward. And I'm just going to talk about that if
Sure,
you'll let me,
please.
just for a small moment, because
yes.
I think this is a really key point that so many clients miss out on. Often the first people they'll pick up the phone to is their technical team. Often, that'll be a third-party provider. And the problem with that situation is that those communications then generally are not subject to privilege, whether that be legal advice privilege or litigation privilege in the UK. And so we can find ourselves in a situation where those very early comms that are being passed around between our client and third parties are not protected. And in the event that a regulator does investigate, or in the event that impacted data subjects do later bring a claim before the English court, all those documents would be disclosable as, in the US, it'd be part of discovery. We call it disclosure. And that then can really open up the doors for liability. I mean, so often what you see put in writing in those first few hours is from employees saying, I've been telling the CISO for months that we should have addressed this. We should have patched this vulnerability. We should never have done X, Y, and Z, whatever it might be. And if those communications are sent outside the organization or even internally within the organization without the banner of legal privilege, what you can do is establish liability for any plaintiff law firm later down the line who wants to bring a claim against your organization. Effectively, you've established liability, and then all they're talking about is quantum. And so that failure to engage legal really from the outset can be the undoing of a number of organizations. There's a really good example I can give you in this
It's
regard,
amazing.
which is a company that I was working with called up their PR firm right from the get-go, because actually the news broke in the media before our client even knew that a breach was happening.
Wow.
And so there was some sort of whistleblower that had gone to the press. And our client called up their PR organization, and the employee within that PR firm duly picked up the phone, took a full note of everything that was said, circulated it to various internal members of their team, setting out everything that had happened. Our client had been very honest, refreshingly honest, probably a bit too honest,
Ooh.
when describing those situations. And we then get a call a few hours later and we get involved. But there was a claim that followed, not for 2 years, but when that claim did then come, those early communications formed part of the disclosure, and it meant that our client was forced to settle a case that it otherwise potentially could have fought if those documents hadn't been made publicly available as part of the disclosure
So
process.
your advice in a situation of a breach is, I imagine the incident team would probably call the CISO of the organization.
Yep.
And the CISO would probably call the CEO, notify the board. And you would say the first external call needs to be privileged.
Yes.
By calling an attorney and then having the attorney deal with PR and everything else.
Yep.
That's a very interesting, very, very interesting point that you make. Thank you for that. So, what has been the most challenging environment you've been in, the most stressful?
There was a really big ransomware attack that I dealt with, and this would have been in maybe 2018, 2019, and it still lives rent-free in my head as being the most stressful case that we'd worked on. And the reason for that is the breach impacted the personal data of a huge amount. We were talking 100,000 very vulnerable young children in every jurisdiction across the world. Because the ransomware had affected a charitable organization who provided very acute support to abused children in third world countries. And there was a real challenge there. Obviously, the charity had to report to the Data Protection Authority. The threshold for having to report in the UK is that there is a risk to the rights and freedoms of identifiable living individuals. So it was easy to assess that that risk had been met. And then the threshold for reporting to the individual data subjects to notify them individually is that there must be a high risk to their rights and freedoms. And again, we assessed that there was a high risk to the rights and freedoms of these young children who were impacted. The challenge that we had was that so many of these children lived in jurisdictions where they didn't have access to the internet, they didn't have access to email. In some situations, they didn't even have access to regular post. You know, they might have one person delivering mail once a month, because they lived in such remote communities. And there was that trade-off then of, is it more distressing to the individuals who've been impacted by this data breach to learn about it and not understand what it means than it is not to tell them at all? And it was a really difficult judgment call to make. And what we actually ended up doing was reaching out to a number of NGOs and other organizations within the area to raise awareness within local communities, and to make sure that the children understood not to be responsive to any unsolicited approaches and that sort of thing. But it was a really stressful situation trying to ascertain in each jurisdiction what the best course of action was for notifying those individual children or their guardians as to the existence of this breach and the fact that all of these children's very sensitive personal data was being made available for sale on the dark web. So that was a really difficult one. And it's one that still lives with me as being very stressful at the time, trying to come up with the right judgment call.
You know, Joanne, when we talk about bringing in the lawyers early on, we talk about governance, all of these are cheap for large organizations.
Mm-hmm.
It's the smaller organizations that cannot afford right? All of this. Security is not
Yep.
cheap. Security is expensive. You got to put the proper people process technology in place. You need to have cyber insurance in place. You got to have your governance, as part of your process framework in place. You got to have the right people. And then you got to have third-party external, PR communications plan for emergency communications. You need to have attorneys, right?
Mhm.
Wouldn't you say that it is out of the reach of the large majority of businesses?
I think it's a really good question, and it's one that we come up against quite a lot, because what we're seeing at the moment is actually it's startups, it's SMEs that are being attacked most frequently. Now, the sums that are being demanded from them aren't necessarily as high as the ones that you might see from the very large technology or the very large healthcare companies. Those are the ones that seem to make the headlines. But actually, it's those small startups and SMEs that, to exactly the point you make, they don't have the infrastructure. They don't necessarily have the people power within the organization to devote time to these things. And often they don't have the funding, as you quite rightly say, to be able to invest huge amounts of money. And so at our firm, what we try and do is produce a retainer package that we can offer to those clients to make it cost effective. It then allows organizations to budget on a monthly basis for what the cost will be and effectively spread that cost out over a 12-month period. And as part of that retainer, you'll get tabletop training, you'll get some wargaming if that's something that your organization needs, you'll get a review of an incident response plan, or we can prepare an incident response plan if they don't have one already, and we can keep you apprised of what the latest developments are in the jurisdictions that you're operating in. And for entities, and we do this predominantly in the life sciences space at the moment, because we're seeing a lot of attacks happening in the healthcare and the life sciences space at the startup and SME level, because they've got such rich data sets associated with their patients. But the value of those data sets, they may not be worth much now, but in months and years down the line, if that product can be shown to be efficacious, for example, then you could be looking at drug manufacture and clinical trials that are worth hundreds of millions of pounds. And so making sure that this data is protected early on is something that we're trying to educate organizations of that size and scale to really prioritize. And we're trying to do it in a way that's as cost effective for them as possible. But I agree with you, it is a big challenge.
That's a very interesting thing that you say. The other aspect of that same comment that I'd like to make, right, is that um, to the general population, we don't see tremendous amount of legal consequences of breaches. We hear about breaches all the time. We hear about the importance of cyber insurance. We hear about the fact that, once in a while you have a regulator, going after an organization for a breach of a regulation. But we don't see prosecutions of directors, of the boards, right, or the leadership of organizations. And as a result of that, do you see that that's a problem, which might give birth to the idea that sometimes cyber insecurity is cheaper than compliance? Because if I want to be compliant, as I said earlier, I need people, process, technology, I need insurance, I need to have Joanne on my team, right? uh, but I'm not going to get prosecuted. There aren't really that many case laws that we can see out there. We hear about breaches all the time. The court of public opinion is most expensive, probably part of that whole piece. What's your take on that?
So I'm actually not in favour at all of personal prosecutions for people in the role of CISO, for example, unless there is obvious
Negligence. Yeah.
unless they're not even negligence, because I think in that situation you should have director and officer insurance policies that pick up for those things. But I think unless there is willful misconduct, for example, on the part of a CISO, and they're choosing, let's say, profits over security, and that's a conscious decision, unless you're in a situation like that, I think the vast majority of CISOs are trying really hard. They're doing the best that they can, often with limited resources. And I think it's incredibly unfair to then be putting the possibility of personal prosecution over these individuals as well, particularly when the budgets that they have made available to them are often not budgets that they've had the ability to decide. That's being decided and given to them by somebody else, whether it's the CEO or the board or whoever. And so I think it's very difficult then to be able to say, if you have a CISO with a very limited budget and something does go wrong, but they'd wanted to do more if they'd had more money, to then point the finger after the fact and say, well, now we're going to hold you personally responsible for this. I think that's a very difficult argument to make. I think it's right that the organization should be faced with regulatory penalties, and that it's the organization's profit that's being hit, it's their turnover that's being penalized. I don't think it's right that we go after the individuals. And we have seen one case of this happen in the US. We obviously had SolarWinds, where the CISO of that organization was held to be personally liable for the failings of that organization. And I know this was a real hot topic of conversation when I was at Black Hat last year amongst CISOs, was, do we think this is something that is going to start becoming more prevalent? And I can't answer that for the US, but at the UK at the moment, it doesn't seem as though we're heading in that direction. But what is interesting is seeing insurance policies starting to provide specific cover in their D&O insurance policies specifically for CISOs in the event of a data breach. And I often think if the insurance market thinks there's a risk and they're now starting to cover it, then maybe this is something that we should start priming ourselves for.
Yeah, the challenge that we have is, if we talk to most CISOs, they would say that there's no denial that CISOs are often the scapegoats. When an incident happens, whose fault it is? CISO's problem. But a CISO will tell us that prior to a breach, budgets are restricted, priorities are cyber is not the primary priority. The other priorities like growth. But as soon as a breach happens, the checkbook is open.
Yep.
And now just make it go away, right? And you're right. I'm not in favor either for CISOs to be prosecuted when the collective decision of a investment into a cyber program belongs to the board, the CFO, the CEO, the entire leadership. But nevertheless, the CISOs are facing the brunt of it. It is reputational damage for a CISO. SolarWinds that you mentioned is a case in point. But having said that, cybersecurity insurance or cyber insurances, while it is getting popularity, the measurement of a cyber insurance and the way you go about taking a cyber insurance, there's no real science behind it, right? It is still an evolving science. So, as a litigator, as an attorney, do you get involved in advising corporations during the cyber insurance policies? Because when you buy cyber insurance policies, you better be careful to read the fine print.
Yep.
That's where the red herrings are, right? What's your take on that?
So that is something that we can help clients with, and it's something that I've also litigated in the past as well. And so
you've litigated a lot.
Cyber is quite a busy space. There's a lot to litigate.
Right.
But one of the things that we've been involved in is, for example, where a corporate has got cyber insurance, they believe that cyber insurance should bite in respect of an incident that they've suffered. For whatever reason, the insurer is saying that coverage is denied. And so we support corporates to bring claims, if necessary, against those insurance providers. So that we're representing the policyholder, trying to make sure that they get the appropriate coverage. But there are gaps, and this is where it's really important, as you rightly say, to make sure that you're reading the fine print, make sure that clients are understanding the exclusions. Because one of the things that we saw in a number of our clients' positions a couple of years ago with the CrowdStrike outage. In fact, I think it might have been just last year.
Just last year, yeah.
Yeah, it feels longer ago than that.
Yeah, it has, yeah.
We had clients that were trying to claim for losses that they'd suffered under their cyber insurance policies, but then their insurers are going, but it wasn't a cyber incident. And then they're looking to business interruption policies, and business interruption policies are excluding things that are IT and arguably cyber related, because they're saying, well, no, that's just covered by separate cyber insurance. And so we had at least 2 clients who fell between the cracks of 2 different insurance policies, and losses that they'd suffered weren't capable of being recovered, because it transpired when you put their business interruption and their cyber insurance policy side by side, there wasn't overlap, and there was this gap down the middle, and these claims fell down the middle. So as a result of that, we helped to advise some of our clients on how to make sure that they had as full coverage as they possibly could for any future events. Didn't help them in respect to the CrowdStrike outage, but hopefully it will mean that won't happen for them again in the future.
Yeah, that's a very interesting point. Still sticking on the point of cyber insurance, right? Do you think that having corporations that have cyber insurance are seeing that as a potential loophole to avoid scrutiny? Right? We have cyber insurance. Sure, we will do the best we can, but we're not going to overinvest because if something happens. Don't worry, that's what we have the insurance policy for. And in cyber, it's very difficult for you to measure what is an appropriate response or what's the sufficient level of response, right? Like in contract law, we learned that your consideration is to be sufficient or adequate.
Yep.
That's a similar situation with here. What's your take as an expert in this field about the sufficiency of a cyber insurance policy versus the adequacy in having the best in class cybersecurity defense mechanism?
Yeah, I mean, what we are seeing is that cyber insurance providers are they're paying a lot more attention to what their insureds are doing now. And so we're seeing a lot more due diligence being conducted by insurance companies at the renewal stage. And so they're sending very lengthy questionnaires so that corporates are having to explain exactly what it is that they are doing or not doing in a particular situation. And in addition to that, we're seeing cyber insurance policy providers insisting that certain actions are taken before the insurance is put in place, for example. So there are things that the insurance providers are doing to protect their position. But what that means is, the possibility of claims arising from that then, if it transpires that something that the insured put in the DD questionnaire before the policy was taken out turned out not to be quite as accurate as once thought, then that gives the insurance provider the option to refuse coverage and, to terminate the policy. So there are ways and means that insurance providers are trying to protect themselves and make sure that they aren't taking on clients and providing policies to organizations that don't have sufficient technical organizational measures in place. But it's very difficult to assess on paper alone.
Yeah. In fact, that's a case in point, Joanne. I've seen a tremendous amount of cyber insurance policies, applications, and the questionnaires are basically asking you, do you have an ISO 27001? Do you have a policy for this and that? Do you have the right people and processes? It has got no bearing to the actual security posture of an organization. But now we are seeing a new form of insurance companies coming up where they're beginning to use automated AI pen testing platform or continuous red teaming platforms to basically determine the cyber posture of an organization. Do you think that's going to become more prevalent than from the present method, which is policy procedure? It's a disclosure, right? Do you smoke? Do you drink? Well, I guess you will not have a heart risk, rather than measuring what's the actual cholesterol level.
It feels like the obvious direction of travel, doesn't it? I mean, I have to admit, I haven't seen this happen in practice yet. So it sounds like you know a lot more than I do on that subject. But it feels to me that that must be the direction of travel. Otherwise, you're relying entirely on self-disclosure of corporates when it's in their own interest to make it sound as though their technical organizational measures are arguably higher than they might be, because that would then result in a lower premium for them with their insurance policy. So I think having that independent assessment being done by an insurance provider sounds very prudent to my mind.
Question is, who's going to pay for it?
Well, yeah, that's always the big question, isn't it?
Right. And that's the way it is. Let's talk about cyber law.
Yep.
Right? Yes or no question. Cyber law, well, I'll make a statement before yes or no question.
Okay.
But you're in courtroom right now. You can only answer yes or no.
Yes, Your Honor.
Cyber laws are national, but cybersecurity is global.
Mm-hmm.
Are cyber laws really viable in a global environment? Yes or no?
Oh, I don't like yes or no questions like this.
Where you guys put through a lot of witnesses in court.
We do.
Yes or no?
I know, but we don't like it when the shoe's on the other foot. I'm going to go with yes.
Fantastic. I would agree with you. And would you say that in a globalized environment where forensics hasn't reached the level where it needs to be, right? We have VPNs that are being used, IPs are pinging from all over the world, and we are unable to. There's so much of issues with regulations and regulatory red tapes that you have across the world that for you to be able to identify an actual breach source, the laws are really national. Is really to deal with national. the laws are not able to deal or grapple with cybersecurity issues which are global.
I agree. Yes.
So how do you deal with that?
Well,
Because there will be, and let me explain, because there will be prosecution, sure, absolutely, if ever, or there'll be litigation, but you're not going to be able to prove or disprove anything anyway. So why worry about it?
So, I mean, the approach that we have to take from a data breach perspective when we're reporting to a regulator, if there are data subjects that are impacted across multiple different jurisdictions, then we would normally reach out to the data protection authorities in respect of all of those, if appropriate. But the way that it works from a legal perspective is that one data protection authority will be designated as the lead supervisory authority. And so they effectively, in that situation, will have overall conduct of any investigation and any enforcement action. And then it's the responsibility of the data protection authorities to discuss amongst themselves if they disagree and who the appropriate lead supervisory authority.
But they can always choose not to respond, which is what happens when you have a not so friendly country that you're dealing with.
Yeah.
Right. Which is why a lot of threat actors use countries that are not so friendly as a launchpad, or at least as a as an inferent of a launchpad of an agreement. So yeah, sure, absolutely, you could ask a foreign regulatory authority for cooperation, for comment, or for assistance, and you will just have nothing back.
Potentially. Yeah, and that does happen. I mean, in that situation, what we would tend to do is look at who the controller of that particular data is from a legal standpoint, and then look to the jurisdiction within which that controller is registered. And so the presumption in that situation then would be that that's the appropriate lead authority to be reporting to.
And if they don't respond back, is that guilty unless proven innocent, or innocent unless proven guilty?
If you report to a regulator and the regulator doesn't respond to you and doesn't take any action, then you've complied with your obligations. If I report on behalf of a client to the Information Commissioner's Office in the UK tomorrow and that data protection authority simply doesn't respond, there's no obligation on us to take it further, as long as we've complied with our obligations under the GDPR to report to the appropriate data protection authority. Then as far as we're concerned, we've met our regulatory obligations.
But when you're dealing with a breach, which might be a violation of a data regulation, we're talking of a breach and a data regulation. Reporting to a regulatory authority is definitely one of the requirements. But there's a breach, and a breach that cannot be proven because it's in a third-party jurisdiction. How do cyber insurance pay? Would they say that, well, we haven't come to a determination because half of the investigations outside of our borders, our laws are toothless tigers, if I may say so, right? And we don't have any way of proving or disproving. And here you have a client that suffered loss with a very expensive insurance policy. Do insurance companies pay? Or do they use it as a card to negate any form of liability to pay?
It can cut both ways. I'm going to give you a horribly legal answer and
it depends.
Caveat that with saying it depends on the facts of the circumstances. I mean, if you have a situation where a corporate has suffered loss as a result of a breach and that corporate can evidence that loss, then it shouldn't necessarily matter to an insurance provider whether it's party A or party B who's liable. That then becomes the insurance provider's issue if they want to have subrogated rights to then go after party A or party B later down the line. But for the purposes of our client and recovering their losses under an insurance policy, that policy should pay out provided that our client has met, notification obligations and it's not excluded from the policy for any reason. So in a situation like that, I would say that it's right that our client should still be paid out. But again, it can depend.
Yeah. So let's talk about reporting. Still on the topic of reporting, Joanne. When it comes to cyber laws, many countries mandate corporations to report a breach, but not the quantum of the breach. So do you see in practice, without any names whatsoever, but is there a lot of underreporting actually happen to the scale? The question is scale of breach.
So no, I tend to find the organizations that I've worked with are very realistic about the scale of the breach, and we'll engage forensic providers to ensure that our clients have got all of the information at their disposal that they need to be able to report to the regulator. What's really interesting is under the GDPR, you have a 72-hour reporting window. It's obviously incredibly short. I mean, how much can you realistically find out within 3 days from the date of knowledge of the breach? So actually what we tend to find in those situations is we put in a very skeletal, what I often refer to as a protective report on behalf of the organization, which often will say, we think there's been a breach, or we know there's been a breach, depending whereabouts we are in the investigative process. We think there's been a breach. We're not sure yet how many data subjects are impacted. We're not sure yet how many records have been affected. But we're mindful of the fact that we have an obligation to report to you within 72 hours.
So here it is.
So here it is. And so we do that on a very bare bones basis to ensure that we've complied with regulatory obligations. And then we confirm to the regulator that as soon as we have more information, we will let you know. And there's an obligation then to provide that information as soon as you can. And so the pressure's really then on us and on the technical team to work together to pull as much information as we can in as short a time frame as possible. Because if it is a big breach, and if I think you can get a sense from the outset whether it's going to be something that's quite catastrophic or whether actually it's kind of fairly contained. If it is something that's quite big, you can expect the regulator to take an interest and be pressing you sooner rather than later for more information.
Right. Well, thank you. Let me try to squeeze out a little bit more of intellectual capital from you, and let me give you a real life, realistic situations that everyone's facing today. So, if you take a look at most organizations, I can't think of a modern day organization that doesn't use some form of AI.
Yep.
You could use ChatGPT, use Perplexity, use Copilot. In the traditional world, it's very common that most organizations sign NDAs. Mm-hmm. Or non-disclosure agreements. And I could have an agreement with company X and have a non-disclosure on certain proprietary information. And that proprietary information, now if you're looking at tools like Copilot, they're already integrated in Word. You're finding them in Word, Excel, PowerPoint. Yes. You find them all over your operating system. But AI doesn't know if that's proprietary or not proprietary information. So now you're releasing information that's within your system, within your duty of care, if I were to use a tortious word, and it is been thrown out to the wild. Mm-hmm. One misconfiguration of not being able to block the privacy of the document, and whether you leave it within your organization or you release it in a web, might mean a breach of a non-disclosure agreement. Now, scale that situation across an organization where there are hundreds or thousands of people that are utilizing this, and there aren't any real controls around AI. This is one of the areas that's giving CISOs a tremendous amount of headache, and I suspect is also going to give a lot of headache to risk professionals and privacy professionals, right? And chief executives of corporations. Do you foresee this as a major legal area of contention where you're going to see lawsuits coming up because you're seeing LLMs beginning to ingest proprietary data of corporations simply because the AI is unable to distinguish what is and what is not proprietary?
Short answer is yes, I do. And you've struck on a topic that I really enjoyed talking about, because I think it's just ripe for litigation, this area. And I mean, I'm not an intellectual property lawyer. There are huge issues associated with intellectual property that colleagues of mine can tell you much more about than I ever could. But I think the area that's really interesting from my perspective is twofold. One is, how does AI then interact with cybersecurity? And the second is then the liability risk associated with the development and use of AI, and who's left holding the baby in a situation where AI goes wrong. And I think if we're looking at AI and cybersecurity together, I think AI can be used really as a force for good in defending organizations against bad actors. But obviously that requires us keeping pace with the bad actors who are using AI in the first place. And if you are, for example, we talked before about insurance companies using AI platforms to red team companies and to pen test, etc. Now, if that AI doesn't meet the standard that's expected, or that AI gets something wrong in that situation, is it right then that the policyholder should not receive coverage in that situation? Or is that an unfair outcome associated with the use of the insurer's decision to use AI in that context? And that's when we start coming into questions of liability associated with AI. because effectively we've got three buckets of users or three buckets of groups. You've got the developer of the AI, you've got the user of the AI, and then arguably you've got the controller of the data associated with the use of that AI. Now, the controller and the user might well be the same entity, but they could be different entities if you've subcontracted your rights for processing data, etc. So you have these three buckets of liability. And if something goes wrong, I can foresee really interesting legal questions being raised around where does the liability sit across those three buckets? And as yet, we haven't seen any cases, at least not before the English court, going through and having judgments being determined in that respect. But I think it's not going to be very long before we do. And I'm really fascinated to see how the English court uses some of our common tortious principles like negligence, etc., to ascertain who in those specific situations will be the ones left holding the baby and having to pay the price for the way that AI has gone wrong.
But I think the biggest problem in this area is going to be around the ability of forensics to keep up. For example, in the example that I gave you, good luck trying to do a forensic analysis on LLM to determine if the source of that leak actually happened from your breach of the NDA. Yeah. So I think there's still a long way to go. But these are definitely issues that we ought to be keeping ourselves abreast on.
Well, I spoke to somebody actually at your event yesterday evening who used a great metaphor that I haven't heard before, but I thought it just fit the situation perfectly. And they talked about it being impossible once you've squeezed the toothpaste out of the toothpaste tube to get it back in again. Yeah. And I just thought it was a brilliant analogy for a situation where you have LLMs, ingesting information that it ought not to. How do you get that toothpaste back in the tube again? You can't once it's out in the wild. It's there. And then should other organizations be penalized for using information that's already out there, even though it shouldn't have been in the first place? It's an interesting question.
It's a very, very interesting question. All right, let's move on. Let's talk about the future of cyber law.
Yep.
Would you think that because of the globalized nature of the world, the UN needs to support the creation of some kind of an international cyber court? Do you think the time is ripe now? Because we're dealing in a globalized world, we're dealing with globalized networks, we're dealing with globalization all across. But yet, cyber laws are very, border-based. They are all covering as what we talked earlier. So would you say that that's probably the next step forward for humanity, that we need to think about the development of an international cyber court, like an international ICJ, International Court of Justice?
I love the idea in theory.
Shall I trademark it?
I think you should. Now's the time. I love the idea in theory. I think from a hypothetical situation, I can certainly see some really great advantages associated with that. From a practical perspective, I struggle to envisage how that would operate when we've got such differing levels
politics.
Of cyber. Well, not just of politics, but also of cybersecurity maturity across different jurisdictions. A friend of mine that I've met whilst I've been out here in Vegas this week is really heavily involved in cybersecurity in Africa. And we had a fascinating conversation yesterday about the work that he's doing in that area, but also how much work still needs to be done and how far behind they are in that jurisdiction as compared to, the US and Europe, etc. And so he's doing an awful lot of work in that space right now, and it's very impressive. But I worry that if you were to have, some sort of global framework or some sort of global organization that would be mandating certain levels, that it would take certain regions, certain jurisdictions just so long just to reach a common baseline. I'm not saying that's a reason not to do it. I just think it would mean we're a long way from being able to see that in practice.
Fair enough. Let's move along. What, from your experience as an attorney, what are the most common legal risks that you see that emerge from cyber incidents today?
So, I think there are common risks to all cyber incidents. And so we're talking here financial loss, reputational damage, risk of regulatory enforcement action. We're talking litigation, often class actions, where you have, huge swathes of data subjects bringing claims. Those are probably the four most common areas that we see. But in terms of the biggest risk or the risk that I see arising most often that people haven't foreseen is what we talked about earlier and the use of privilege. And that's probably the root cause of so many of my war stories is the way in which organizations have failed to use the legal team to the most advantageous way possible and to protect themselves as much as possible.
What about internal legal teams? Is that privileged?
So in certain jurisdictions it is. In the UK, yes.
US?
I'm not sure about the US.
You worked in the
actually.
US for more than a decade.
No, I worked in the London office.
In the
of
London
a
office,
US
okay,
law
for
firm.
the US law
Yeah.
firm. Okay.
So it was
Fair
always
enough. Yeah.
English law was always the jurisdiction.
So for
that I
English
worked in.
law, I could, well, not me, but if someone has an incident, they should involve their internal legal teams, because under British jurisdiction, that's privileged information.
100%. Yeah, it doesn't have to be external lawyers. You don't have to pay for somebody to come and do it. It doesn't have to be me or anybody like me. You can absolutely make use of your in-house legal team in the UK. It's different in Europe. And so, for example, take France. If you're an in-house lawyer in France, then privilege does not attract any of your communications, internal or external. And so it's very good to be aware of the different jurisdictions that you're operating in.
So CC your lawyers in every email in and out. Make it as a default statement.
Well,
you're privileged from everything.
Unfortunately, it doesn't quite work that way. The courts will look to substance and not just the form. So
Right.
It's not quite as straightforward as being able to slap privilege across everything and just copy in your in-house lawyer. The in-house lawyer has to be providing legal advice. They have to be substantively involved in the discussions that are taking place. So we do have to make sure that we're kind of putting it against that
There must be
backdrop.
some reasonableness
Yeah,
that
exactly.
ties that ties around it. Well, that's a very interesting point. So let's talk about an actual situation for our audience. If there is a actual data breach in an organization, we know that there is a cross section between forensics,
Yes.
cyber law, and cybersecurity. There's a cross section between the three, because if you can't prove where it originated from or where the liability is, then that's a problem. Cybersecurity is where you want to make sure that you are making sure this doesn't get repeated and there were no negligence that was involved. And the legal part is making sure you take care of liability. Have you seen missteps in the area? Because that's a very difficult area to navigate between forensics, cybersecurity, and the entire legal aspect of it, right? Can you share some war stories of real life experience?
Yeah, for sure. And I should say up front, I'm a really big believer in technical and legal working very closely together. I think there is a huge amount of value that each team can gain from the other. I mean, not least because I don't understand half of the technical stuff that is going on in the background. You know, we have specialist teams for that reason. They know what they're doing. And I like to think there's value that I can bring from the legal perspective too. But I think the more you can integrate with the technical team that you're working with, the better. And I think it's really important to have those good, strong relationships. And it's one of the reasons why I really advocate for technical and legal to work together from a cyber resilience perspective, so that you're not just meeting the technical team for the very first time once a massive breach has happened. In an ideal world, you would have a technical team and a legal team that already know one another, that perhaps have worked together on the incident response plan, perhaps that have worked together on testing the incident response plan or doing some war gaming with the corporate in question, so that if or when a breach does happen, those teams already know each other. They're well versed with working with one another. They've got a good relationship, and there's a level of trust there. Because I do think a lot of the honesty and the efficacy of being able to work with a team in a very high pressured situation like a breach, which, let's be honest, for most clients is their worst nightmare come true, particularly if you're the CISO. This is the day that you hope never happens and it's materialized. And for everyone, that's incredibly stressful. What you don't want is the communications between your technical team and your legal team to be disjointed, or for somebody to be, inadvertently undermining the other, or for them to be contradicting one another in correspondence or not being aligned. And so I think if you've got a pre-existing relationship between technical and legal, it makes everything from the point of breach onwards so much more straightforward. And I think that's probably the area in which I've seen, from a war story perspective, things not going right and there being a mismanagement from a communications perspective. And perhaps the technical team has got one point of contact within the client and the legal team has got another point of contact, often within the legal department, and the technical team often have got a contact within the business department. And if there isn't that joined up messaging, you can find yourself in a situation where perhaps the business is going out to the open market and making statements that the legal team would really rather they hadn't had delivered, without first having aligned all of that messaging and making sure that everyone was all on the same page. Because if you have a situation where public statements are being put out there, particularly if you're a listed company, you can find yourself in huge amounts of hot water if those public statements then affect the company's share price or impacts, the way the market reacts to the information. If that information wasn't exactly on point with what the legal team believed should have been put out, you can find yourself being investigated by the FCA, as well as having an investigation being conducted by the Data Protection Authority. And that is a true story. That is something that I've seen happen. And so you do have to really make sure that your legal team and your business team via the technical team are as joined up as possible, and that everyone is on the same page, not just when it comes to public statements to shareholders or to the market, but also, from a media perspective as well, because you make one misstatement to a journalist and, everything can change very quickly overnight. And that's something that I think nobody wants.
Joanne, thank you very much for the fascinating conversation. It's not always that we get attorneys in here for this conversation, but this has been an amazing conversation, and I'm sure our listeners have had a tremendous amount that they've taken from this talk. So thank you for coming.
Thank you for having me.
That was Joanne Elieli from Stevenson Harwood LLP in the UK, a senior partner for litigation for the law firm. From that conversation, you have seen the importance of keeping cyber first in mind is not always about the bits and bytes, but it's also about the cyber law and how you respond to it. If you've enjoyed listening to this episode of the Cybersecurity Podcast from AC Council, don't forget to like and share and subscribe to the YouTube channel. And I will be seeing you again. This is Jay by VC checking out, and I'll bring to you some of the brightest thinkers in our industry to shape a safer digital world. Thank you and goodbye.